Thanks, Mr. Adams. Is there a national security component to your work?
There is, Senator, sitting in the Office of the Deputy Attorney General. One of the benefits that this task force can draw on is the ability to call on experts in the DOJ's National Security Division as well.
So you're not just involved in law enforcement. What your work has national security ramifications for our country.
It does.
The department presently does or does not have authority to transfer the proceeds of seized assets to Ukraine.
As a general matter, there are limitations on that. In the broad sense, there are limitations on what forfeited funds can be used for and how they can be directed towards law enforcement aims or crime victims. And in this instance, there are limitations that would prevent most forfeited funds from being provided.
So if we provide you with the necessary authorities, you can work with Treasury and State to accelerate the delivery of needed funds to Ukraine.
That's correct.
Under administrative forfeiture, there is a cap on the assets that can be forfeited at $500,000. As a practical matter, how does that affect your proceedings?
Senator, that's correct for most classes of assets, including assets like large luxury yachts or assets that are found in bank accounts. What that means is that with respect to those assets for which administrative forfeiture is not available, what we would do in the department is file a civil forfeiture suit if we were going to pursue civil forfeiture as the mechanism to fully, finally, and permanently divest somebody of their property interests. The other option, of course, is to bring criminal charges and to resolve a criminal case against a particular individual.
Let's talk about administrative forfeiture for a minute and the value of proceeding in rem. In rem, for the record, means against the asset itself, does it not?
It does, Your Honor. Senator.
So it's okay, you've been in court a lot more than you've been
That's correct.
Senate hearings. There's very clearly established law that highly mobile assets can be made subject to in rem forfeiture proceedings, correct?
And more than just highly mobile assets, but those as well, yes.
Yes. And the kind of assets we're talking about may actually be highly physically mobile themselves, but they also may be highly legally mobile in that their ownership may be screened, say, behind a Cypriot account, which is holding a Cayman Islands corporation assets, which were contributed through a Dakota trust, which are all hidden behind a Panamanian law firm, and all of that is movable by the bad actor. And the way you cut through that is to make it grab the asset based on evidence that it should be seized, and now you're proceeding against the asset, and you no longer have to chase through all those screens. Now the claimants have to come forward themselves to make their case. Is that correct?
To put one point on the table there, with respect to seizure of the asset in the first instance, and this is true in administrative forfeiture proceedings as they exist today, what we need to do is go to court. We have to show probable cause that an asset is forfeitable in the first instance. And what that may mean, what that often means, is piercing through those levels of opaque financial networks at the outset. Afterwards, if you go through the administrative forfeiture route, then you're correct. We provide notice and to give the opportunity for owners to come forward and make a claim if they wish to put their name in association with a particular asset.
And conceivably, say, the skipper of a Oligarchs yacht could provide testimony, yeah, actually, this belongs to this guy. He's the guy who comes all the time, and we know him to be the owner, and that would be enough to begin proceedings. Similarly, evidence that comes out of the intelligence community could provide evidence to begin proceedings, correct?
Yes, with of course, there are limitations on what we can do with classified information, but generally,
and certainly in terms of releasing it. In the due process area, none of this authority begins without a presidential declaration, the authority we're working on right now.
I'm sorry, the draft legislation that
Correct.
you're working on, my understanding is that the draft includes a presidential declaration.
Yep. And you don't start these things without some initial evidence of ownership to begin with, correct?
Correct. Again, as I understand the
You
proposals.
might call that predication. Sorry to interrupt, but my clock's running out.
Not at all. The predication has to exist, and what I have seen essentially maintains the requirement
Yep.
that the Department of Justice seek
And at
seizure.
the-
What that means is that there needs to be a probable cause showing to a judge before this process begins.
And at the end of the day, there is a judicial proceeding with the asset as the subject of that proceeding, and anybody who wishes to make a claim to that asset, to say that they're an innocent owner, can come forward, subject themselves to cross-examination, testify under oath, and provide a legitimate proof of ownership. There is, in fact, solid due process in this proceeding.
What I have seen is that there is an opportunity first to come forward after notice in an administrative hearing, and the ability to challenge administrative findings in front of an independent court afterwards.